Hey guys, Jamal here from SCR Credit Services. Today I wanted to talk briefly about pay for delete. If you don't know what pay for delete is, pay for delete is an arrangement that you make with your creditor that you will pay the account in full, or at least settle the account in full, in exchange for them to remove the account completely from the credit report, as opposed to showing the account as paid in full, but keeping the item on there. Okay, and you may or may not know that a collection item can stay on your report for up to 7 years, even after it's paid. So a lot of the negative collection activity that you would see on that item would still be reporting there. Okay, from a professional standpoint, you would always want to at least negotiate a pay for delete before you attempt to try to pay an account in full. And it is a case by case situation. I do have to say that it's not always the case where you would suggest a pay for delete, and it's not always the case where you would actually achieve a pay for delete. Okay, so that's pretty important to understand. It is a situation where results may vary. So I wanted to discuss with you a little bit more about pay for delete, and then kind of share with you some of the strategies that we would use when dealing with collectors. Okay. Now, first off, you may hear from a lot of collectors when you're trying to get a pay for delete initiated. Some collectors will say, "Hey, well, we can't do a pay for delete because, according to the Fair Credit Reporting Act, all information has to report to the credit bureaus accurately," and this is true. Okay, but in this scenario, it's kind of like a half truth because yes, the information that is reported to a credit bureau has to be 100% accurate, complete, and verifiable, right? But it's perfectly legal to not report information, okay? And so that has to be understood as well, right? This is why a lot of times you'll see on a credit report that you might have an item that's reporting on Experian, but it's not reporting on TransUnion, right? Or it's reporting on Equifax, but it's not reporting on Experian. This is because there's no law that says they have to report information to all three bureaus. There's no law that says they have to report any information at all, right? This is why, as a credit repair company, we're only going to refer our clients to credit opportunities that will report to all three bureaus, okay? Because otherwise, it's not a strategy to be used for credit building if they don't report to the three bureaus. Furthermore, there's even an e-Oscar code that you can use, which will stipulate that the creditor has agreed to do a pay for delete and they haven't. Okay, so you can actually use this as a dispute reason, right? And it's encoded into eOscar. If you don't know what eOscar is, it is the throughway, so to speak, the electronic throughway that credit reporting agencies use to communicate your dispute to the furnisher of that information. They're getting thousands of disputes pretty much every day. And so as a result, they need a systematized way to communicate your dispute over to those bureaus. So what that means is ultimately, even though you may have an elaborate dispute, right? Tons of paperwork, you've got proof, you have, copies of your bills and all of this information. When that stuff gets sent over to the credit reporting agencies, all of that information gets reduced down to a or three-digit code, right? That really represents the reason behind that dispute. Okay, we go into eOscar in another video, so I'm not really going to touch on it too much here, but there is an eOscar dispute code that you can use to claim that the company will delete the account, right? So I want to talk a little bit about a client that we had in this particular case. and I'm going to show you guys in a minute. I'm going to show you a response that we got here. But in this particular case, we did a debt validation for MCM, which is Midland Credit Management. They're also Midland Funding LLC. You may know them as that as well. But we did a debt validation to them, and we also did a simultaneous dispute to the crediting bureaus. And in this particular case, it did result in a deletion. Now, that's not always the case in every situation or with every client. And so results always, will vary, so to speak. And so, one of the things that we do is we always tailor a strategy based on the client's specific disposition of accounts, right? So we don't really have one kind of cookie cutter system that we use because we've noticed we don't get the same results every single time. Okay, so it's very difficult to have that cookie cutter system. We find that you get the best results by being as dynamic as possible. Okay, and so this letter that you're going to see here shortly is a letter that the client received shortly after an investigation, right? Where we got this item deleted from the credit report, but then they sent this letter, and it discusses the change in their credit reporting policy. Okay, so I'm going to read you this letter really quickly so you guys can follow along with me. So the purpose of this letter is to make you aware of a recent change to our credit reporting policy. Effective October 11th, 2016, we will request that existing credit reported trade lines for any Midland Credit Management or Midland Funding account be removed when the account reflects a paid status of a zero balance and it has been 2 years or more since the date of delinquency. Okay, and then it says the date of delinquency can be found on your credit report, and it's the first date when the account becomes past due. Okay, so what Midland has done is they've given us kind of a map to follow if we want to get a pay for delete. They're saying, hey guys, we'll give you your pay for delete, no problem. We just have to make sure that the account is reflecting a zero balance, right? And it is at least 2 years from the date of last delinquency. On the surface, you guys can kind of use this information, in your campaigns, and I'm sure that it'll be helpful. Okay, and frankly, if you're creative, you can kind of use this against other collection agencies as well because they're all following the same law. So if Midland can do it, then how come this company can't do it or this company can't do it? Okay. I said that we get the best results because we try to be as dynamic as possible, and so what that means is we try to create our defenses based on the responses that we get from them. Okay, so if I'm looking at this letter, I'm going to look at this letter like we look at any letter, right? We're going to scrutinize the letter itself because in reality every letter is a contract. Okay, now we're not lawyers, all right, we're not attorneys. We are a licensed credit repair firm. Okay, we don't practice law, and for the purpose of this video, this is for education only. Okay, but from an educational standpoint, you have to observe that for the most part, when you receive documents like this, documents, when they come to you, usually come to you in the form of some type of contractual arrangement or contractual agreement. In law, they have what's called a tacit agreement. Okay, a tacit agreement. And tacit agreement means that you're agreeing by your silence, right? By your inability to rebut the information that is contained in that correspondence, you are actually agreeing to it. Okay, and it sounds maybe counterintuitive in a lot of ways, but it is how a lot of consumers get caught up into bad situations. Because ultimately, when a creditor sends a letter to a consumer and that letter contains information or a set of facts, and the consumer does not rebut those facts that are contained, then they indeed become facts and they become truth, right? And it allows that creditor to move on under the assumption that the consumer is in agreement with what's happening. Okay, so and the reason why I say this is because one of the first things I'm going to draw my attention to is the fact that it appears as if they're trying to validate this debt by simply listing the name of the original creditor, the account number, the MCM account number, the current balance, and the current owner. So when I see this, I see that they are slyly, sneakily trying to validate this debt. Is sneakily a word? They are trying to validate this debt by simply listing this basic information. Now we've already asked them for much more information than this, but this is what they came back with. But the fact that they are outside of that 30-day parameter, they've put it inside of the four corner rule so they can kind of protect themselves in that way. Okay. Now, there's also a very curious statement on this document, and it's at the very bottom that says this account may still be reported on your credit report as unpaid. Okay. Now, I call this a curious statement because if they cannot validate a debt, okay, then they cannot pursue collection activity. Now, I'm not sure if you guys are aware of this, but reporting collection information to a credit reporting agency is considered collection activity. Okay? So when I look at this statement, it says this account may still be reported to your credit report as unpaid. Now, as a consumer, okay, I will look at this and I will say that may could just mean will, and it could read this account will be reported to your credit report as unpaid. Okay, it really matters how the consumer ingests the information that they receive from the credit reporting companies and from the collection agencies and things like that. Okay, the way that the consumer interprets things is the entire basis of consumer law, not so much how the creditor spins it, all right, and puts the legalese on it, but it's how the consumer feels about it, right? So as a consumer, if I read this and I say, hey, wait a second, you guys haven't even validated the debt, but yet you're saying you're still going to report this information to my credit bureau. Now they're walking a fine line here because this technically could be construed as a violation of the FDCPA, the Fair Debt Collection Practices Act, Section 807, which deals with false or misleading representation. The debt collectors cannot falsely misrepresent any information that's reported to the crediting bureaus. And not only that, but they certainly cannot threaten, right, to report information to the crediting bureaus on you onto which they know to be false. Okay, that would be a violation of the FDCPA. I'm going to look at that and I'm going to say, let's have one of our attorneys look at this letter, and let's see if this could be something that could be indeed a violation. Okay. Now, lastly, I'm going to point out something on this letter that I'm not sure if anybody noticed, but on this letter itself, you will see that there is no mini Miranda on this letter. Okay. Now, all debt collectors are required to express the mini Miranda, whether verbally or in writing, when they communicate with you. Okay. So I don't know if you've ever noticed when you call a collection agency, the first thing that you usually hear when you call a collection agency is this is an attempt to collect a debt. Any information obtained can and will be used for that purpose, right? And so when you hear that, that's called a mini Miranda, and they are required to express that to you over the phone when you call, and also in writing. Okay. What's very important when you get these letters back from the collection agencies, look for that mini Miranda. Do you see it on the collection letter? If you don't, that could be a violation of a consumer protection law, okay? Namely the FDCPA, all right? So in any case, you always want to make sure that they're acting in compliance when they send you these documents and these notifications. Okay, I hope you guys can take some information from this. If you'd like a copy of this letter or any information that we talked about, hit me up on Facebook, send me a message, and I'll be more than happy to help you guys out with that.